Hello everyone. Bonjour et bienvenue. I'm Ruth McHugh, Chair of the College of Patent Agents and Trademark Agents. I now call the 2026 Annual General Meeting to order. As a federal regulator responsible for the regulation of patent agents and trademark agents in both English and French, our staff and licensees live and work throughout our vast and free nation. I'd like to begin by acknowledging the land we call Canada as the traditional and ancestral territory of many Indigenous peoples, people who have lived on and cared for these lands for generations. Today, we're gathered in Ottawa on the unceded, unsurrendered territory of the Anishinaabe Algonquin Nation. We're grateful for the traditional knowledge keepers and elders who are still with us, and for those who have gone before us. We respect the histories, languages, and cultures of First Nations, Métis, Inuit, and all First Peoples of Canada, whose presence continues to enrich our communities. Today's meeting is being simultaneously translated into French. Dana Dragomir, our Director of Communications, will explain how to access the French interpretation. Dana?
Oui, bonjour tout le monde. Donc, si vous voulez écouter la session d'aujourd'hui en français, que vous soyez ici avec nous ou en ligne, vous devez vous rejoindre au lien Zoom et l'écouter avec vos écouteurs sur votre téléphone. Et dans le Zoom, vous devez cliquer le globe terrestre et en bas de la fenêtre, puis sélectionner la langue française. On va juste vous demander de vous mettre sur mute pour qu'on ne vous entende pas.
Thank you, Donna. And thank you to all of you for attending. Today is a really special celebration because 2026 marks the 5th anniversary of CPATA coming into force. It's our 5th birthday party, and we have cupcakes later, but we'll talk about that later. I think I speak on behalf of all directors and staff when I say, wow, what a journey. It's hard to believe that it's already been 5 years since we began fulfilling the important mandate the Government of Canada entrusted us with. I'm so proud of the way CPATA has brought balanced regulatory rigor to these already strong professions, but more on that later too. Today we'll spend about an hour presenting, followed by about 30 minutes for questions, both from our in-person and our online participants. To ask a question through Zoom, please enter it into the Q&A section, and we'll get to it during our question period. For everyone in the room, please come on up to the microphone that's in the center of the room here and ask your question. Following the meeting, we invite everyone to stay for an informal reception with some light refreshments, which are cupcakes. So I'm going to start by introducing the table. I'm joined today at the head table by Judah Straczynski, our CEO and Registrar, Jen Slobodkin, Director of Registration and Education and Deputy Registrar, Victoria Reese, General Counsel, Professional Regulation, Sean Walker, our CFO, and Dana, you've already met. In the room, we're also joined by some of our board members and our committee chairs. No, our committee chairs were not able to make it. They were with us this morning, but not here now. CPATA is fortunate to have directors and committee members at its helm with such diverse and deep expertise. When I call your name, if you're in the room, please stand so we can acknowledge you. And I'm going to call everyone's name, though, just so we can acknowledge all of our directors. Amber Batul. Amber is with us online today. So, Amber, thank you for all you do for the college. Karima Bawa. Karima wasn't able to be here today because she was busy chairing an IPON meeting, so she couldn't be with us today. Tom Conway. Tom's here with us. Thanks, Tom. Eris Almedicote. Eris, thank you. Thank you. Anne Abigail Fisami. Anne Abigail's not able to be with us today. She was with us this morning, but not this afternoon. Steve Garland. Steve, thank you. Dennis Hasko. Thanks, Dennis. And Scott Jolliffe. Thank you, Scott. Thanks so much. During the reception later, it'll be our pleasure to speak with you. I'm going to now pass the baton over to Judah to share more about CPATA and the major accomplishments of the college over the past 5 years. So over to you, Judah.
Thanks so much, Ruth, and thanks for joining us, whether you're in person or online. It's an exciting time to be at the college, turning 5. Time flies, and it's been a rocket ship as far as professional regulatory organizations go. And so what we thought we'd do today is, now that we've zoomed up, we've got that perspective, we can zoom out and spend some time talking about the accomplishments, not just of the last year, but also to date. And so there's a lot to cover. We're of course the independent public interest regulator of patent agents and trademark agents in Canada, and we've set a vision for ourselves based on our enacting legislation to provide the public with access to a globally respected body of patent agents and trademark agents who are highly skilled, ethical, and current in their knowledge. You know, I'd be remiss if I didn't note that while this regulatory structure has been in force for 5 years, it didn't come from nothing. Patent agents and trademark agents have been providing this vital work for 100 years in support of Canadian intellectual property and Canada's participation in the global economy. So the creation of the college represents a recognition of the essential role that patent agents and trademark agents play in Canada's IP space and in our very national fabric. The college's creation also brings in line the Canadian approach with the global standards of recognizing patent agents and trademark agents as professionals and having a modern national regulatory framework within which they operate. Regulation matters. I don't think any of us would be here today if it didn't. Just because it functions in the background doesn't mean its impact is negligible. It is the connective tissue that helps to build trust in these professions and helps to connect innovators and businesses to IP expertise when they need it, so they can take their ideas and achieve success with the professional support they need. Regulation is at once a foundation and it's a safety net. It creates the clear and transparent standards, such as through our professional code of conduct, and it has scaffolding such as our ethics articles and educational videos to help licensees meet those standards. At the same time, we provide safeguards for when there are concerns that those standards aren't being met or where agent conduct may have caused harm. And we'll discuss today, CPATA's introduced mandatory insurance and has proactive approaches to reduce risks to clients and a range of tools available that we deploy to protect the public and consumers. So in 5 years, we've modernized the regulation of patent agents and trademark agents in the public interest, enhancing the trust relationship of clients and licensees, and strengthening Canada's innovation system. We're also getting to know a lot more about the professions and the clients they serve. And one of the things that we've done as an early accomplishment to the college was get a better understanding of who these professionals are and what they do all day. I sort of joke that there's that wonderful kindergartner's book. It's this big yellow book by Richard Scarry called What Do People Do All Day? And you can flip through it and there's a dog who's a police officer or that sort of thing. There's no patent agent there. There's no trademark agent there. So we had to take this up a notch. And so one of the things we've done is in 2025, just this past year, we expanded out our annual report. We always ask licensees to confirm certain key information for us so that we can keep track of where people are working, what kind of insurance they have, et cetera. We started to ask other information so that we could better understand the work of these vital professionals. And starting last year, we had them answer some key questions that help us understand how we can effectively regulate as light touch as appropriate and to serve consumers and work with our partners, including the federal government, licensees, and innovators, so that we can continue to regulate so that there's a responsive profession that meets the needs of the public. So today we're going to just share a couple of snippets of some of the data that we've gathered in the first 2 years of this expanded report. It started in 2025, and as renewal happened again in early 2026, we've just taken a cut at the first data there. And so we're seeing some multi-year trend property office, or who can do everything except present and prosecute before CPO. They get to hold themselves out as agents, however, and do IP work in a regulated sphere. Over 900 of them were patent agent licenses. 1,179 were issued as both C1 and C2 on the trademark side. And so you can see that there's slightly more trademark agents than patent agents. It's important to note, though, that there are approximately 22% of our licensees, just 427 as of this count, it'll range through the year, who hold both a patent agent and a trademark agent license. And so they can practice in both professions and be sort of a one-stop shop on that. We can see that there is a bit of a concentration, which partly reflects some of the economic centers of innovation in Canada and concentration of population. We can see there are a lot of agents in Ontario and Quebec. We see some then in Western Canada, Alberta, BC, slightly lower numbers in Eastern Canada. I would add, though, however, that this is a global profession, and Canadians can access professionals from across Canada, especially with the technology that we now have. Turning to the numbers by license class, you can see a breakdown here. And an important factor for us as we consider how we regulate is to consider in the terms of consumer access the demographics of the professions. How many agents are leaving the professions to retire for other reasons versus how many are coming through our trainee platforms so that we have a sustainable profession. What we're seeing is some leveling off, and this is a positive for Canada. It's normal in the early years of professional regulation where there are increased requirements and expectations from the public that some people will choose not to continue on as a professional within a regulated sphere. We saw some of that in the early years, and part of that was that we had taken CPO's roster of people who had at one point become a trademark agent or at one point become a patent agent, and some of them would pay the renewal fee just to stay on a register, but they hadn't been doing this work. So when we came in and said, if you're doing this work, you need to take on mandatory insurance, the costs increased and they realized they weren't doing the work, and so they left. That made sense. And we've got lovely and quite entertaining stories about talking to professionals who are sort of head scratching and saying, I'm a family law mediator now. Do I need this license? And we could say, well, we can't make that choice for you, but do you plan on prosecuting a trademark in the near future? And they would then govern themselves as they saw fit. So we now are seeing that the numbers are stabilizing. We've generally been seeing more of a 2 to 4% decrease of trademark agents year over year. The number of patent agents leaving the profession has been balanced out by the Class 3 trainees who are entering. And so this is positive in terms of the sustainability of the profession. Another important note is that the number of Class 3 agents, those who are in training, they're the future of the professions, and we're seeing an increased number in those categories overall. So we had 57 new agents in training licenses issued in 2025. So people starting the journey in 2025 as compared to 36 in 2024 and 47 trademark agent and training licenses granted in 2025 as compared to 39 in 2024. So these are small numbers, but they're trending in directions that are intended to facilitate access. All of this information becomes extremely important to CPATA, since our core goal is to ensure access to competent and ethical agents. We want to make sure that the innovators and creators can access the IP supports they need, and it becomes important for our financial planning as well, which we'll get into because our budgets are based on licensing fees. So we need to know how many people year over year are going to be in the professions in order to make our budgets as prudently as possible. What are some of the other things we learned when looking at our annual licensee report data? Well, currently, as I said, there are more trademark agents than patent agents. We also know that trademark agents are more likely than patent agents to also be licensed as lawyers. We've also learned that there's a diversity of practice. We know that there's significant diversity of practice setting as well. We know that many practice in law firms as lawyer agents or as agents who are partners or associates in multidisciplinary law firm practices. But we also know there are significant numbers of licensees who serve as agents within IP agency boutiques. We also have people in-house who are providing IP support with different levels of support, different levels of skills being applied. And we have some in corporate settings, we have some solo practitioners, solopreneurs, and we have others working in government or in academia. So the data shows a robust ecosystem, and we're seeing that, that when it comes to the type of work being done and the types of industries they're serving, and this you can see as well when you look at top filers by patent or by trademark, but the type of protection being done and the type of work that they do, we ask them which industries they serve. And there are differences between a trademark practitioner's role where there's more likelihood to be working on consumer packaged goods, consumer products, food and beverage, clothing and apparel, and those sorts of areas, software. And that's because of the brand, right? That's about marketing. That's about market penetration and understanding your demographic and getting that recognition out there. Patents, the patent practitioners are more likely to be working in areas of the economy related to medical devices, software, chemical, engineering, biotechnology, AI. They also do work related to consumer products and manufacturing, just like trademark agents also do work to market the medicine, to trademark the name of a drug, to work in those areas, but the volumes are different. And so they serve different industries in terms of by volume, which is important for us to understand and recognize. Turning to what our licensees do all day, and Jen's gonna describe this a bit better, but before the college was created, we didn't really have a very good sense of what agents did all day from a regulatory perspective. And, you know, it's not just about drafting. And so what we did is we asked licensees, what do you do all day? And we've known generally what they do, but now we have data to break that down further. We know that for both patent agents and trademark agents, filing, drafting work is a significant part of practice, but they also both spend a significant amount of time on IP management, on strategy, on advisory work, and non-lawyer agents at times are brought in to support when there is litigation going to a court. They also at times appear before tribunals before the Canadian Intellectual Property Office themselves, be it the Patent Appeal Board or the Trademarks Opposition Board. So they have really interesting practices that are quite diverse in terms of the kind of work they do. And from time to time, when there's a merger, an acquisition happening, the IP agent will be brought in to help with the IP assessment or to explain the portfolio and work with other professionals, be it lawyers or accountants, bankers, financial experts, so that people can understand the value of a business, the value of an IP portfolio, or what needs to be done to transfer it elsewhere. So it's a diverse scope of work, and it touches really on several different pillars of professional practice. It involves legal, but it also involves strategy, which involves business, and it involves real technical knowledge and applying that every day with the skills that they acquire. So now that we've seen who CPATA regulates, let's talk a bit about the founding principles of CPATA, what we were set up to accomplish and the milestones, because it's important to know that environment that we're in. It took us some time to see that environment more fully by asking questions of licensees and working with them. So CPATA came into force. It's crazy to rewind this. Jen lived it as employee number one, but we came into force 5 years ago in the middle of a pandemic. And it's incredible to see now what we've built. The core of our work involves instilling a culture of professionalism in licensees, some of whom have never been regulated before, And so we've built a transparent, comprehensive regulatory framework for the professions. And we've had to do it from the ground up to build a brand new federal, bilingual, professional, modern, and virtual regulator. And it was no small feat to become independent and financially sustainable as well. So I want to thank everyone who helped get us there, because it couldn't have happened without the Government of Canada, without licensees and their engagement, without IPIC, without ecosystem partners and other IP funding agencies, the founding directors who were literally putting the college on their personal credit cards as they tried to get it moving. There was no startup funding. And each and every staff member and committee and board member who's been part of this. So when we were established, there were several principles in mind. The first was that CPATA serves the public interest. And that's still a term that some are unfamiliar with, and understandably so, but it's a sort of term of art that professional regulators use to indicate that we recognize that we're here to try to advance public good. And that means there are different publics and different angles and lenses we need to apply to our work. And we actually have mapped out who we serve. We did something a little different because public interest is sort of a catch-all phrase that regulators use. We actually created a paper that's part of our governance documents that describes that to us, the publics we serve include our licensees, as well as innovators and creators, or consumers, if you will, as well as the general public. And you'll see as we describe some of the work we do, how we engage with each of those different publics and must do so to meet our mandate. The second is that we should be independent. That was clear from the legislation that created an independent board model. And it was important to be entirely separate both by government, who runs the Canadian Intellectual Property Office, and professional associations that do a lot of things that advance the public good, but where there can at times be tensions between a regulatory interest and a profession's interest. It's necessary to ensure the public interests remain our North Star, and independence is reflected both in the structure of our board and our enabling legislation, and also in how our committees are structured, but beyond that, also how we are funded. We are independent, we are independently operating, and we are funded independent from any source. We have not taken money from government. We have not accepted money from associations. It's driven by licensing fees and by fees related to other regulatory activities such as exams. We also try to embody what is described as right touch regulation. And that is just to say that we try to be evidence-based, outcomes-focused, and neither too burdensome nor too permissive. It sort of feels like Goldilocks sometimes, but we're trying to strike a balance here so that there are policy decisions where there may be a range of options, but we try to not be too onerous. We're trying to make sure that the public is also protected, or that licensees are well served. So it's always contextual, but we're always trying to figure out that right fit. And sometimes that will mean light touch, where we're doing very little in a space. Sometimes, depending on risks, it might have to be a little higher in the ranges available, but it's always going to be based on the circumstances, based on the evidence. So what do we deliver? Overall, we have a broad mandate. The core can be distilled into 4 key areas. First, we help Canadians confidently find licensed patent agents and trademark agents through a searchable public register of all licensees and foreign practitioners. And we'll talk a bit about how we've set that up in a second. 2, and Jen's going to speak to this, we develop standards of professional competency that give a clear understanding of the expert and ethical services that the public can expect to receive from agents. Third is we've established clear, fair, equitable entry to practice requirements, including supervised practice training and qualifying examinations that promote readiness for real-world practice. And finally, we address concerns of licensee misconduct according to a professional code of conduct and unauthorized practice by non-licensees, which can include fraud, and we're going to have more to say about that. These actions are at the core of what we do, and they safeguard the public, They hold confidence in the professions and the college and protect the integrity of our IP system. Although generally during an AGM, we present the annual report, the financial statements, and update on progress from the last year, I just want to note that all of the resources, including our strategic framework that closed out last year and our new strategic framework that is guiding us into the new year, are all available online. We're going to sort of touch on them in passing as we go, but we're not going to, present them all fully here and get into all of that minutia today. So what I'd like to do, though, is talk about we'd like to share some of the more impactful initiatives of the last 5 years, and we're going to go down the table and share by areas where our wonderful staff has led. And so I'm going to pass to Jen momentarily, but first I just want to talk a bit more about access, because that is one of those cores. And so I mentioned that one of the things we do, and it's by statute, is we have to have a register of our licensees. And historically, regulators were mandated to create public registers, and you'd go online, and the question would be, well, is the name that I've been given matching a name that's on the register? And is that person in good standing? Nobody wants to go and find out that the person that they thought they were buying a house from is not actually a realtor, but you sent them a deposit check, right? That's scary stuff when there's an unauthorized person out there. It's also scary if you've signed up and you're expecting to go in for surgery and you check the name and you realize this person's been suspended and maybe I shouldn't go in for that surgery since they don't appear able to practice. So we have the same sort of system. It's infrequent that we have a notation about somebody in terms of discipline. We're low volume, and we'll talk about that in a bit. But at a minimum, you want to know, is this person a professional? Are they in good standing? We've taken that a step further. We've tried to become more consumer-centric, which is where some regulators are headed. So our register now, with the help of licensees providing further data, now allows people to do more detailed searches, which reduces the friction point, which is a real point of difficulty for consumers. It helps them guide towards agents who are most likely to best serve their needs. So some of the things we can search for are things like language of service, not just Canada's official languages, bien sûr, on va les inclure, but also other languages spoken, so that in a global world, those seeking assistance can have the assistance in the language of choice. We also can search by location. You might want to go into somebody's office and chat. We can help facilitate that by checking where they're located. Of course, if you would rather search by what area of practice you offer by industry, you can also drill down by that. Our agents have answered where they have served in the past, which helps give an indicator to the public who might be able to serve them going forward. You can also set different parameters to drill down further by multiple fields, and that allows people to see who within the pool might be available. The most important addition we have is that agents now can indicate whether they're open to taking new clients or not. So now we have a good filter, and that's helpful for both the public and licensees. I used to be a professional in legal practice, and it was disheartening when you'd get cold called, which would happen, and which happens to agents from time to time as well, where somebody has found you off a register and says, can you help me with this? And the answer is, absolutely not. I cannot. This is nowhere near me. Or, I cannot. I only take clients from these institutions. I do not serve this group because of conflicts. Now we have the ability to narrow down a little bit so that those who may be licensed but operating in-house and not serving in a forward-facing client setting, or those who already have their institutional or other client base and are currently swamped and not open to taking new clients, they can indicate that. So that helps the licensees in terms of when they're reaching out to know that they have a better shot at connecting with the right agent who will suit their needs. So with that in mind about where the consumers are being served, we're going to turn to competency, which is the other part. We want access to competent, ethical individuals. And so Jen is going to tell us about competency. Jen?
Thank you. Thank you so much, Judah. As Judah mentioned, I oversee registration and education, and I'm the Deputy Registrar and Director of Registration and Education at CPATA. So my area of responsibility covers everything to do with competency, entry to practice, which includes supervised training and exams, as well as continuing professional development. So basically, what you must know to be an agent, how you become an agent, and how you maintain those skills over time is within my portfolio. As Judah mentioned, CPATA is committed to facilitating public access to expert IP services from a robust body of highly competent and ethical practitioners. And since inception, we've been looking at the entirety of how to enter the professions. As such, our overarching priority for the first 5 years was and continues to be professional competency and entry to practice. This is really the crux of how the regulator can contribute to the IP system by ensuring that there are clearly outlined technical and professional expectations of practitioners and ensuring that the pathways for becoming a licensee are fair, assess the required competencies properly, and remove unnecessary barriers to entry. For many years, there were no clearly defined overviews of what must agents do to practice competently, and we created the first ever competency framework for patent agents and trademark agents, which outlines the technical and professional knowledge and skills required to practice. Through this, we've defined what is truly required to be an agent and what's expected. From the adoption of the technical competency profiles in 2023 to the adoption of the professional foundations competency profiles in 2025 by the board, this created an unprecedented, clear description of the knowledge and skills that licensees need to provide competent service to their clients. The profiles were developed through a very rigorous process, which allowed for input from agents and other IP stakeholders, including working groups of licensees and a survey of all licensees in both professions. This rigor has had an impact on consumers who now know what to expect of an agent. It has an impact on future agents who now know exactly what it takes to be an agent. And it's had an impact on current agents, for example, those looking to keep their skills up to date through CPD. Now, we want the future generations of agents to succeed, to be competent and ethical, and to be able to pursue the career that they have chosen. And here are some things that we've done to support that. We've redeveloped the qualifying exams. Since our coming into force, IP stakeholders have raised concerns about the exams. We began to redevelop them after the technical competency profiles were approved in 2023 to align the exams with those profiles. The new exams were administered starting for the first time in 2024. With the help of over 100 licensees, we launched an entirely new exam regime which tests against the knowledge and skills outlined in the technical competency profiles. Several changes support candidate success on these exams. We hold exams virtually, so there are no barriers or excessive costs associated with travel or accommodations to write the exams. We've aligned them with the competency profiles and the approved test specifications so that they're transparent with what will be tested and that we're ensuring that we're measuring the correct competencies that are required for practice. We also split the exams into two types of exams, the knowledge exams, which test foundational knowledge, and the skills exams, which test applied skills, so that candidates demonstrate competency on each part separately and can better progress through the exam process. In 2025, we reduced knowledge exam eligibility criteria from 24 months of supervised training to 12 months of supervised training in order to reduce unnecessary delays in entry to practice. And starting in 2026, Class 3 agents in training who have completed at least 12 months of supervised practice by the examination date were eligible to start attempting those knowledge exams. In 2025, the knowledge exams for patent agents and trademark agents were offered twice per year. So in 2024, they were only offered once per year, but in 2025, we offered them twice per year and onward, both in winter and in spring. And this allows agents in training who maybe aren't eligible by the winter exam or who aren't able to demonstrate competency on that first administration a second chance before the annual skills exams are administered in the fall. We also offer sample exam questions, we hold candidate orientation sessions, and we facilitate live proctor check-ins to make sure that candidates are familiar and comfortable with the exam platform and the process in advance of the exam days. Although this is a pass-fail exam, we provide candidates with information about what knowledge areas they met the standard in or not, and how close to demonstrating competency they were, so that they can better prepare for future administrations. We also built a scoring process whereby each exam is automatically marked separately by 2 exam advisory group members, and any candidates that are close to the cut score are marked by a 3rd independent advisory group member. Ultimately, we want to ensure that candidates are set up for success and that they have clarity on what will be tested and have the opportunity to acquire those knowledge and skills during their supervised practice period. We want to ensure that the exams measure the knowledge and skills required to be an agent fairly and defensively. The other major component to entry to practice in these professions is the 24-month of supervised training program. In order to become an agent, one must complete those 24 months of training and pass the qualifying exams. To support internationally educated and trained professionals seeking licensure in Canada, we developed a policy that considers their prior experience toward that 24-month training requirement. This process provides a flexible approach and removed unnecessary and artificial barriers to entry for IP professionals who are coming to Canada. After completing the competency framework and redeveloping the exams, we turned our attention to investigating the strengths and challenges of this requirement. We began in 2024 with a wide consultation, which included focus groups with over 50 participants and a survey of agents, including trainees and supervisors, which was completed by over 100 licensees. We also held roundtables at the IPIC conference. CPATA engaged in outreach and received submissions in response to the consultation paper. Through that consultation, we identified opportunities for improving the quality of the supervised training experience or to find complementary pathways that may augment the supervised training requirement. For example, we heard during the consultation that some trainees struggle to find supervised training opportunities and that employers had difficulty recruiting trainees and providing various training experiences. We heard that supervised practice could use better scaffolding, for example, through the development of template resources. Based on the results of that consultation, we undertook some immediate steps as early as 2025 to improve the experience for trainees and for supervisors. Our goal was to reduce friction and provide connection, resources, and scaffolding to support a successful training program that instills the knowledge and skills required for successful practice. One of the changes we made was to the public register, so they can now connect through the public register where supervisors can indicate if they are looking to supervise a trainee, and trainees who are already registered with us can indicate that they are looking for a supervisor. Supervisors and trainees were also surveyed on how we should be creating resources for supervised practice, and they were invited to complete a survey last fall to help us understand how trainees are exposed to competencies as well as supervision and workplace strengths. The survey data is being used to inform the development of 3 new assessment resources, which will be available in 2027. The first is a training plan, which is a tool for supervisors and trainees to use for structuring their 24 months of training. A progress track document that can be used to track the progress of trainees at 6-month intervals throughout their training program. And a final evaluation, which is a tool for supervisors to evaluate the trainees at the end of their training experience. This may provide some much appreciated scaffolding to support trainee success and good relationships between supervisors and trainees. The resources are being developed this summer by working groups of licensees and will be available in early 2027 with more information to come at that time. As you can see, the perennity of the professions and the progress of individuals wanting to enter these professions is key to us at CPATA, as it will impact not only career plans, but access to IP expertise and Canada's innovation economy overall. We welcome anyone who wants to provide feedback or to work with us on these initiatives, so please come and talk to me during the reception if you're interested. I will now pass it on to my colleague Victoria, General Counsel of Professional Responsibility, to tell you about how CPATA has protected the public through professional responsibility initiatives during our first 5 years.
Thank you, Jen. You've been a little busy.
Yeah, just a little bit.
By contrast, I've had nothing to do. As General Counsel Professional Regulation at CPATA, in addition to providing some general counsel services to the CEO and staff and board and committees, I manage the ethics inquiry, agent conduct inquiry, complaints and discipline processes, as well as unauthorized practice, so all the nasty stuff. But I get a great deal of joy out of some of the work, and, well, all of the work, but in particular when I get to deal with licensees on ethical issues and provide some guidance. So one of the key ways CPATA has supported a thriving IP system in Canada in the past 5 years is by overseeing the ethical and competent delivery of services by patent agents and trademark agents. And this means striving through both proactive and sometimes, when necessary, reactive means to support licensees in understanding and adhering to the Code of Professional Conduct for patent agents and trademark agents. Since CPATA is coming into force in 2021, all agents are subject to a mandatory code of conduct for the first time. And so this is really the cornerstone of professionalism. And it's been a process of education, encouragement, a little bit of scolding in terms of getting agents through this transition from not being under a mandated code of conduct to being subject to one. But we do find that CPATA's licensees are all highly motivated, principled, and professional individuals. And so we try to provide resources to help them in nuanced situations. Right. So since CPATA came into force, we've been publishing ethics articles on various topics to help guide licensees. So this is all part of this proactive educational approach. And these articles take the common inquiries that I receive and Judah receives, and we proactively provide information for licensees. And today, we're really pleased that we have a searchable database on our website where you can look up the articles based on topic, based on rule in the code, and these are accessible to licensees inside their licensee portal account. Presented by experienced, in 2025, we also created, this was a really exciting project, 3 foundational videos on the Code of Conduct. And these are accessible to licensees, on their licensee portal account. Presented by experienced agents and covering topics such as integrity, conflicts of interest, and communications, these videos provide patent and trademark agents and trainees with a much deeper understanding of their duties under the Code of Conduct, and also helpful practice tips. So the structure of the video is to do some of the talking head piece, and then to bring it into reality with scenarios, and then to end with the practical key tips to take away. Video 1 is an introduction to the Code of Conduct and the fundamental canon of integrity, which rule underlies all of the rules in the code. And videos 2 and 3 go on to an in-depth dive into competent and ethical communications, covering a wide range of rules from competence, quality of service, confidentiality, conflict of interest, marketing, retainers, and withdrawals. It's sort of everything, but from a communications perspective. And CPATA also occasionally does webinars or participates in conferences on topics such as the due care standard or generative AI in order to provide guidance to licensees. So we're likewise available to our licensees as a guide before things go wrong. So there's a form on our website, an ethics inquiry form, that licensees can use to ask CPATA a question. about how to apply the rules to a particular scenario. Some regulators are reluctant to do this out of fear of the risk that it brings, that you're going to create some liability and that it's risky to provide advice. But we believe that ultimately licensee's judgment is what matters. But if we can help support that professional judgment, then that's in the public interest and it's in licensee's interests. So we've received all sorts of fascinating questions since the start of CPATA, nuanced matters which require careful consideration in light of the code. And you can see some of these on screen. So if I take incoming work from a foreign client via instructions from a foreign agent, is the foreign agent or the foreign client considered my client? That's an interesting question, and I'm not telling you the answer. Is it a conflict of interest for me if a registered mark in a trademark application of one client is cited against the trademark application of another client? And this one is interesting given that in certain areas of practice, there may not actually be many practitioners in that area. And what are my ethical obligations and responsibilities if a client seems to have diminished capacity to make decisions or to provide instructions due to what appears to be a mental disability? And so I can tell you this is one of the favorite parts of my jobs because it's like working through a puzzle and figuring it out and getting what you need to know and helping the agent understand how the rules might apply, but ultimately encouraging them to use their professional judgment. So when we receive an ethics inquiry, we do an in-depth analysis and then provide the licensee with our guidance, again focusing on encouraging them to use their professional judgment. In the coming years, we're going to continue to expand our ethics and practice guidance. This is a real added value to a licensee's fees for what they get. So we're trying to help them practice, and we're going to expand into practice management resources and tools, which is a really exciting project that I'll be involved in. So all of these efforts support our public interest goal of proactively helping agents become and remain competent and ethical. So if we turn now to protecting the public and the complaints and discipline side, beyond the proactive support that we provide, we are committed to protecting the public when things go wrong in the case of professional misconduct or incompetence by agents or unauthorized practice and fraud by non-agents. CPATA has built a professional responsibility system and has handled complaints and discipline cases since the very day of inception. And when IP clients need it, it's essential for them to have somewhere to go for help and to know where to go and how to access it easily, regardless of your language, your cultural background, your geography, anything. So CPATA has worked hard to build and maintain a fair, open and right touch complaints and discipline process. And we use a tiered, risk-based, principled and proportionate approach. So we start with the informal inquiry. This is if you look at a filter, everything comes in that way, and that's the focus on early resolution. What are the issues? How can we resolve this without it having to become a complaint or an investigation? Then we have the complaints and investigations, and this is a structured, evidence-based review. And if necessary, then we have the discipline committee adjudicating complaints. And this is the process, a public process, for the serious cases where there's clear evidence of professional misconduct or incompetence, and there are meaningful public protection sanctions. Transparency is incredibly important for the credibility and trustworthiness of this organization. This framework balances public protection, fairness, and the promotion of ethical, competent practice with the patent agent and trademark agent professions. So we're fortunate that for the size of this organization, the number of licensees, that our complaints experience has still remained relatively low. I think some of that is because people are still figuring out who we are and what we do, but I also think that agents have a real commitment to ethical and competent practice, and that the number of complaints has stayed pretty low over the last 5 years. One thing I want to highlight is that there's a high number of matters resolved through early resolution. 70% of complaints are resolved or closed without referral to the investigations committee, and that's primarily my job. Similarly, in 2025, out of 17 agent conduct inquiries received, 16 of them were resolved through early resolution. This is about 94% success rate. I am bragging a little bit. This is a good thing because an informal resolution process means that it's a quicker and more efficient way to resolve concerns about an agent, and everyone comes out more satisfied than having to go through the being traumatized or re-traumatized through an investigations process. That is the nature of an investigations process. So in addition to experiencing a relatively small number of complaints and investigations, the number of referrals to the discipline committee has also been low. That's an average of 1 to 2 a year. We've had as many as 3, and in 2025, no referrals. So the discipline committee hearings, policies, and procedures are transparent and open to the public and conducted in accordance with regulatory and administrative law best practice. I do want to say, excuse me, on a side note, that CPATA is seeking to recruit 3 new members for the discipline committee, 1 licensee and 2 non-licensees. We've had tremendous interest and received numerous expressions of interest, primarily from non-licensees, which is really exciting. We're hoping to receive more expressions of interest from our licensees before the June 15th deadline. So information about the discipline committee and how to apply is available on our website, and I really recommend that people have a look at that. And anybody in the audience knows somebody that comes to mind, please reach out to them and say, hey, have you heard? So then we move on to unauthorized practice, which has been an unusually busy area. In recent years, the Canadian IP rights holders have been targeted by rampant phishing scams from bad actors. And we've worked diligently and with partner organizations to build consumer awareness and to try and shut down fraudulent communications and websites. Throughout, really starting in August of 2024 until literally this morning, members of the public have been targeted in phishing attempts by fraudulent individuals and companies urging immediate action and response with payments to prevent threats to individuals' intellectual property. And these frauds have gotten increasingly complex and sophisticated in the 2 years since I've been involved with them. They're using artificial intelligence to craft messages and websites that appear very legitimate. At times, they appropriate the names of licensees and lawyers and then change the addresses and emails and contact information. They're harvesting information from public databases and websites such as CPO and increasing to increase the air of legitimacy of these communications. In this past week, I've had 2 individuals reach out to me who've lost $600 each, believing that they were responding to a CPO examinations officer who was insisting that in order to get to the next step of protection, they had to send in $600, and they did. And then they contacted me and said, might this be a fraud? So we're trying to work on getting ahead of that a little bit. So CPATA has aggressively responded to protect those targeted, and to date, we've received and responded to well over 400 expressions of concern from just the phishing scams, published multiple notices advising public caution, worked with authorities to shut down fraudulent websites, launched a new fraud webpage, centralizing notices, tips to spot fraud, and contact information to alert CPATA, offered a fraud prevention webinar with CPO and the Competition Bureau, and otherwise collaborated with CPO, IPIC, and other partners. We are not afraid to name and shame the fraudsters. We're also pretty unique in that regard. So on a dedicated web page, we've listed the names, the business names, the emails, the phone numbers of the fraudsters. Haven't heard from one to suggest that we have misnamed them or done something wrong. Tell you that. We provide sample emails and offer tips to help victims identify that they're being phished. We know this is helping. I get feedback from people who now don't just send in a form and say, can you tell me, have I been scammed? But they say, I went to your website, I noticed that this and this information is there, so I think this is a scam, but this is what's different. Does that change anything? And so now they're halfway there, which is fantastic. We've also responded to unauthorized practice concerns about non-agent lawyers and others, even C3 trainees, who have been marketing IP services that they can provide that they're not authorized or eligible to provide. And so their marketing or advertising can be potentially misleading to the public. about the extent of services they can provide or how they're describing their services and whether there is even a patent or trademark agent involved. So in these cases, I look at the websites, social media, LinkedIn, Facebook. I contact the firms directly and say, depending on how far over the line they've gone, hi, we're CPATA. Did you know that you're actually, that this is what CPATA does, and this is what an agent does, and this is not what you can do, and here's what you're saying on your website. Could you please change it? And sometimes it's, excuse me, you know, I get a little different tone. So I've had a lot of success because most of the time it's an innocent mistake or it's a misunderstanding, and I've gotten very good response to that in probably half a dozen cases anyway. So we've invested significant time and resources in helping protect the public from being defrauded in such a nefarious way, and will continue to act in the best interests of the Canadian public in reaction to this scam. So now I'm going to pass it back to Judah to talk about some other areas of our progress.
Thanks so much, Victoria. That was so great to sort of bring to life some of those stories. Thank you. Really appreciate it.
Yeah, the fraud stuff is really, it's quite malicious, and you know, we take these cases, and even when you save somebody, the mental anguish these cause is really significant, and it's really quite validating for us to be able to help somebody. You know, one of the calls that I took was from somebody who called from their hospital bed after receiving a cancer diagnosis, and in the middle of that is getting spammed 4 times a day by a fraudster saying, your trademark is expired and I can help restore it, but you need to send me money now. And I was able to tell this person there are bigger battles to fight, go fight them, but know that this is a fraud, don't deal with this, and away we could go. And so, you know, it gives people peace of mind back when they're able to pull that connection, see that that fraudster is being tagged by us, and we get a lot of thankful emails there. I know that this has been much bigger than what CPATA operates in, and we're thankful that ISED has recently consulted on it, and we're looking forward to working with the Government of Canada. I know that CPO and others have really shone a light on this and done more to support Canadians so that they don't become victims of these schemes. It's a very broad net, though, and it's a sophisticated one, so we all have to work together. We're also grateful to the Government of Canada for consulting recently on client-agent privilege. This is a matter that's very important to the college and has been since inception. You know, the regulation of the college came following the grant of client-agent privilege to patent agents and trademark agents in Canada. And we've seen in the early days that there's been a little bit of choppy waters around the extent of the privilege that ultimately is there for the client and to protect the client as they deal with sophisticated technical legal issues. We've been working closely with the Government of Canada on this, and our position remains that we are of the view that the agent-client privilege, which is there to help innovators and clients, should mirror the work that is done by these licensed professionals, where there is a college in place in case anything were to go wrong and require investigation. We are authorized to go in and see what's happened. We can pierce that privilege. But that privilege at the core of it is vital to enhancing trust among professionals, which is one of the reasons that the college was created in the first place. So we're here, we're cautiously optimistic and continuing to work with the Government of Canada to try to advance this on behalf of clients, on behalf of Canadians, on behalf of our innovation system to the betterment of all Canadians. So with that, I'm going to turn it to Sean, and we're going to get to the part around finances that any good AGM is going to have. But stay tuned, because it's a good news story.
Okay. Thanks, Judah. So I'm going to speak first a bit about financial sustainability and then get into the housekeeping with the audit and our next year's budget. So we'll talk a bit about financial sustainability. It's extremely important to CPATA's independence that we have the necessary resources in place to help us function long-term at no cost to the Canadian government or to taxpayers. So as Judah mentioned, CPATA's inaugural board was appointed to set up the college in 2019 with absolutely no funding from any source. So they were putting expenses on their personal credit cards, went on for a couple of years before we were able to get a line of credit, which was backed by the Canadian government. This did put us in a precarious position for a regulator who's supposed to be independent from government and financially sustainable, but it was a necessary step that we had to take. And since then, in 2023, in order to be sustainable and meet our mandate, we managed to pay back the debt, remove the Government of Canada as guarantor on the line of credit, and build financial reserves to cover the operations and any potential high-cost regulatory matters. And back in 2023 was when we increased our fees and really made that push to start funding our reserves. We've maintained our virtual operations, which has allowed us to be national in our operations, as national in our operations as the professions that we regulate throughout the country. And it has allowed us to save hundreds of thousands of dollars in office and rent costs. And we are able to recruit our staff according to the regulatory experience and not just their location. Okay. And we are a small and mighty team of 8 staff plus Victoria, diligently working from our homes across Canada. And as Victoria also mentioned, since we're a low-volume regulator, we don't have any full-time investigators, counsel, prosecutors, a tribunal coordinator, or investigation committee counsel. But with that said, we are prepared for complex cases by having the right expertise available on demand and by having the financial reserves already set up now. So 5 years in, CPATA is in a very healthy financial position with the new strategic framework from 2026 to 2028 beginning this year, and we now have a good idea about the major initiatives and priorities on the horizon. Okay. So now I want to talk a little bit about how we budget and how we come up with our expenses. So CPATA's overarching budget principle is to have the sufficient funds to meet our statutory mandate and provide long-term stability for the organization. CPATA is transparent about our budget processes, and all our budgets are publicly available on the website. And CPATA's annual budgets are approved. CPATA's annual budgets for the following year are approved each December with the board's in-person or public December meeting. And CPATA's revenue budget is calculated by taking the projected number of licenses that we'll have for the following year by the fee amounts that have been set. And then we add in additional revenue from exams, applications and certificates, and also from interest income. And then we build our expense budget on a zero-based budget method where we try to build from the bottom up, make sure that we can assign all costs to something tangible. We tend to base that on our prior regulatory experiences regarding core regulatory functions. And our major expense categories, of course, are our 8 staff members, board of director and committee remuneration, professional competency and exam development and administration costs, and legal fees mostly related to professional responsibility. We've also been contributing to building financial reserves. So regulators require reserves to ensure that we have the stability, continuity, and resilience of the organization. And it's best practice for regulators to set aside a certain amount each year overall so they can invest the money and safeguard against unexpected events, address unpredictable, unbudgeted expenses, and respond to emerging needs, support investigations, and discipline matters as they evolve. And reserve funds are even more important to CPATA as a new regulator, since college does not have any historical or trend data based on our complaints or various things just yet. And then in 2024, as I mentioned, we established 2 separate reserve funds. The operating reserve fund was used to set up the college, used to support the college's day-to-day operations in situations where we may see a significant drop in revenue or an increased unexpected expenses. We also have the Professional Regulation Reserve Fund, renamed the Professional Regulation Unauthorized Practice and Litigation Reserve Fund. It's a mouthful, I know. It was set up to support the college's professional regulatory costs, including legal fees, investigations, complaints, discipline, and unauthorized practice matters that exceed our annual budget allocation in those areas. In 2023, we actually undertook a review of the reserve policies and information of over 50 Canadian regulators to try to find some best in practice type of situations and targets. So we were able to update our targets to the amounts to the appropriate for the long term. So our new target amounts are a minimum of 6 months of operating expenses for the operating reserve. So that's currently set at 1.6 million. And we've set 2 million aside for the professional regulation, unauthorized practice, and litigation reserve fund as well. So a combined 3.6 million in reserve targets. By the end of 2026, we expect to meet these full reserve targets. That is, if we don't need to withdraw any funds from the reserves before then. This leaves us in a very good position to adjust license fees for 2027 and going forward, and Judah will speak a little bit more about that soon. Okay, now to the housekeeping, the really exciting stuff. All right, so we again had our audit at the end of December. I'm going to be giving an overview of the highlights. However, our full financial statements are available on the website under the About Us reports section. Okay. So the Audit and Risk Committee met with the auditors from Doane Grant Thornton in mid-March and recommended the approval of the financial statements to the board. The board was then approved them on March 24th, and as mentioned, there's a full copy of all the reports on our website. We had a successful year-end audit for 2025 with a clean audit opinion, which really means that the financial statements presented fairly in all material respects the financial position of CPATA at December 31st, 2025, and again, there was no adjustments or misstatements in the financials. And another housekeeping note is that CPATA is a not-for-profit entity, of course, for accounting and income tax purposes. Therefore, although we're not subject to income tax filings, we do have to file an annual information return with CRA, which we have done. And also, CPATA follows the Canadian accounting standards for not-for-profit organizations. So some of the results from the audit and from 2025, the financial results were very favorable. We ended the year with a surplus of 1.3 million, which was 1.38 million, which was 300,000 better than the budget we had put forward, which was 1.8 surplus over budget. This is very similar to the result from 2024, where we had a surplus of 1.43 million. And even though we did have lower than expected fee revenue in 2025, we were able to keep expenses well under budget, and the surplus was allocated to our net assets reserve to get it up to now 3.1 million of that 3.6 million that I mentioned, target I mentioned. Okay. Perfect. Also, so to highlight a few areas of the finances, we'll talk about the college's financial position. So this is shown on the balance sheet or the statement of financial position. On the asset side, we had $3.2 million in assets. It's mostly made up of cash and GIC investments, with some other small amounts for our HST receivable at year-end, prepaid expenses, and capital assets, which you will see are these 6 or 7 computers that we own. Okay. For the amount showing in the liability section, it was only $150,000, and this relates to supplier invoices not paid by the end of the year, and some payments that were made early in the year to individuals on committees for the fourth quarter support they provided for the regulatory, education, and competency initiatives. And as for the net assets or reserves, as we mentioned, the surplus contributed to the amount of 3.1 million, and that was an increase of 1.4 from 2024. Okay. Now, just a quick rundown of some of the financial operations from 2025. So revenues between 24 and 25 are very similar, just over 3.9 million. We did see a decrease in application fee revenue, but that was offset by an increase in the number of exams that were written. And we were also able to conservatively invest in a GIC and received interest income in 2025, which continues into 2026. And again, we mentioned we were very conservative with our expenses and ended the year $340,000 under our expense budget, which then allowed us to get that $300,000 surplus. Okay. And now just some quick notes around the budget for next year, or this year now, since we're in 2026. So this is the third year of our multi-year plan to build the required financial reserves, and we should, as I mentioned, we should reach our targets later this year. The budget for 2026 was built with a plan to add approximately $740,000 in annual surplus to the reserves, and we do expect to have about a $200,000 reserve surplus if all things go equal for the rest of the year, which is part of the reason we were able to consult on fees, and Judah will explain the results soon. And for revenue for 2026, we increased our fees by 2.2%, and that's based on CPI as required by our bylaws. And we have other items, we've projected an increase in exam writers, and we think the interest income is going to be static or a little better. We have more money to invest in GICs, excuse me, but we're seeing slightly lower interest rates, so we figure it should even out over the last year. And then under expenses, we've continued to develop a number of numerous programs, so exams and competency, continued professional development, supervised practice. And it's these new projects and the continuation that we've seen an overall increase in expenses of 347 over 2024. But as I mentioned earlier, we do expect to see a surplus by the end of the year, so that's from those. And as I mentioned, CPATA operates in a very lean manner with only our 8 staff plus Victoria and no physical offices, so we continue to monitor and try to keep expenses as low as possible. I'll now pass it back to Judah to talk about fees.
Well, thanks, Sean. I think Sean's teed this up nicely. Our finances have come a long way. The sustainability of the regulator is secure. And so with that, we're excited to provide an important announcement about the fees, which is simply that there is a reduction coming. In early 2026, we modeled projections for our expenses and revenues to propose licensing ranges for 27-28. We then held a call for comments on the proposed licensing ranges, and we're grateful for the submissions we received, including from IPIC as well as just over 30 individuals. Globally, the feedback received indicated that fees should be reduced, and there were various proposals about the range of amounts that we could take this fee to. Since the opening of the call for comment, CPATA also closed out 2025 that Sean just reported on, and it was quite positive. And we've started into 2026, and we're well along. Licensing renewal for 2026 also closed on March 31st, and so our staff, our audit and risk committee, and our board of directors carefully were able to review all of the new feedback provided from the call for comment, as well as our budget data, our financial projections, and our licensing renewal data for that trend line about licensing so that we could confidently move forward with reduced fees. So this morning at their meeting, the board of directors held a meeting in public where they approved a 25% reduction to Class 1 and Class 2 patent agent and trademark agent license fees. The single agent Class 1 fee is now being reduced from $1,877 to $1,400 for 2027. This fee is even lower than the range proposed during the winter call for comments, which was proposing a range of $1,450 to $1,550, but we were able to reduce it further based on the financial data, the license renewal numbers, and the submissions we received in response to the call for comments. So of course, the fees for patent agents and trademark agents are higher than before regulation. There is an exclusivity that comes with being regulated. However, that does not mean that licensees can write or should write CPATA a blank check. So we're striving to keep the fees low while having the resources we need to meet our extensive mandate. We're also relatively new in terms of our track record. So we've built our operations gradually, but we do not expect to expand much going forward. The reduction adopted by the board today is not insignificant. We did say from the outset that we were going to build to scale to address our ongoing sustainability and financial reserves so that we'd be ready if a big wave hit, like a complex case or rampant fraud as we're starting to experience. But now that we're well equipped and ready for those situations, we're prepared, as we said we would, to scale back fees. It's a significant reduction based on solid forecasting, and we hope that we expect it'll be sustainable. We also expect that this reduction will address some of the concerns from solo, small firm, and in-house practitioners who had sought particularly reduced fees for their practice settings. So rather than reducing the fee for just certain categories, we've reduced it across the board. The Schedule 1 of our bylaws is where you can find our fees, and the amounts for 2027 adopted by the board today are expected to come in for January 1st, 2027. Now that's conditional on CPATA's bylaws, which are drafted in conjunction with the Department of Justice, being amended in time for these changes. But we're working closely with the Department of Justice, and currently things are looking good and on track. So you can see here there are other fees that are impacted by reduction. You can see the reduction of those who are both patent agent and trademark agents, as well as reductions for Class 2 licensees, as well as the dual Class 2 licensee categories, all reduced by approximately 25%. So we have information explaining how we reached these conclusions in a memo that went to the board today and is in our publicly available board materials. It reflects the processes that we had taken to then consult and call for input. We received that input. It is considered in that memo. And you can see that there were many groups that brought their expertise to bear, and I'm grateful to staff for their forecasting and expertise, to our Audit and Risk Committee and their professionalism and expertise, and ultimately to the board for making yet again another difficult decision in the public interest that seeks to balance competing needs and competing priorities. But going forward, ultimately for January 1st, our intention is to bring the fees down to these levels and then to be indexed to inflation as they have been to date on the go forward, but from these lower rates. I'm going to pass to Dana now to talk a little bit more about the work that we do, how we do it. This call for comment was but one of the different ways that we engage with our different publics. And so, Dana, over to you.
Thank you, Judah. As Ruth mentioned at the beginning, I'm the Director of Communications for CPATA, and today I'm going to talk about something that's hopefully a bit more fun than fees and finance, although I guess that's subjective. Thanks, Tom. I want to talk about how CPATA stays connected with the various publics that we serve. I want to give an overview of the kinds of initiatives that CPATA participates in and how you can get involved in the work of the college in various capacities. There we go. So CPATA regularly engages through conferences and webinars with licensees, innovators, and Canada's IP ecosystem, and with other regulators to share and learn best practices for public interest regulation. This is an important way for us to both share our expertise and to learn from others, and to hear from others as well. For example, we seek opportunities to engage with licensees where appropriate. So, for example, in 2025, this included speaking at IPIC's annual conference in Saskatoon. We also spoke on the topic of due care in an online webinar held by the Commission Canadienne de la PRAM. And just earlier this week, Judah spoke on an IPIC panel about agentic AI for professionals and ethical issues. Our engagement with our IP partner audiences and the public is also diverse, and recently has included attending the Innovation Asset Collective's National IP Summit last year, and more recently working with CIPO and the Competition Bureau on a fraud prevention webinar in March, which is Fraud Prevention Month. We also recently presented to innovators about working effectively with IP professionals with BC's Digital Supercluster. And then we have the regulatory side. So we try to share our regulatory expertise with other Canadian regulators. The Canadian Network of Agencies for Regulation, we are regularly at their events, or we present at their events. Our CEO spoke this winter at an international conference dedicated to the challenges and opportunities of generative artificial intelligence for professional regulators. And later this month, Victoria will be providing the opening remarks at the Council of Licensure, Enforcement and Regulation, also called CLEAR, at their regional symposium in Halifax. So we're definitely not a regulator that works in isolation. We are out there, we're connecting, we're sharing, we're learning, and we're building the relationships that help make us agile, effective, modern, and connected. So there are many ways to stay in touch with CPATA, to provide your thoughts on various issues, and to contribute to our projects. So we regularly hold open public consultations. In the past 5 years, this has been on everything from insurance, competency, supervised practice, fees, and more. So thank you to the hundreds of licensees who have over the years completed our surveys, participated in focus groups, provided written submissions, or talked to us about these issues. The information and perspectives we received have informed our approaches in these areas, have shaped policy decisions, and have really given us the information that we need to do our job properly. We are regulatory experts, but we rely on our licensees and other partners to give us industry or practice perspectives or to tell us of the expected impact of certain decisions. So thank you again to everyone who took that time. So these slides will be published on our website, and each of those links is clickable in French and in English to see open and past consultations. There are also many ways to work with CPATA to contribute to the patent agent and trademark agent professions directly. We rely on support from subject matter experts and licensees. We consider that the work of regulation is professional and requires expertise, so we do compensate the people who work with us for their efforts. We have 5 regulatory and governance committees. We have exam advisory groups, we have boards, and we have various other working groups that are sort of ad hoc. So each of those gatherings of people we have to, populate. Currently, as Victoria mentioned, and I'm really glad she did, we are looking for 3 members for our discipline committee, especially licensees. So I'd just like to reiterate that June 15th is the deadline for that, and anyone who is interested in throwing their hat into the ring, it's a really important committee for the college because it adjudicates complaints of professional misconduct or incompetence, and it hears those applications referred by the investigations committee. There's another working group that is currently underway, and we're seeking bilingual reviewers to supplement the work of that group. So that group is developing supervised practice training resources. So it's the resources that Jen mentioned, the template training plan, the progress check, and the final evaluation. So we're at the stage where we're going to be translating, and we want to ensure that there's equivalency between the documents. So we're looking for 2 patent agents and 2 trademark agents who speak both French and English for these roles. So in general, all of the information, again, the second link, the work with CPATA, that's where you can find open opportunities. And there's also overviews of all of the opportunities that we're currently not recruiting for, but that might come up in the future, for example, our board or other committees. And of course, I wouldn't be doing my communications job properly if I didn't tell everyone to follow CPATA on social media and to subscribe for our newsletter. We do send out a monthly newsletter. All of our licensees automatically receive it, but any member of the public can sign up to receive it as well. And we are quite active on LinkedIn, although we're also on Facebook and X. So please follow us. And I'm gonna pass it back to Judah.
Thanks so much, Dana. You can see it's a busy shop, and it continues to be busy as we look ahead. So just wanted to, we've seen where we've come from, and it's been a remarkable journey. Now let's look at where we're headed. So there's a single-page document online that describes our strategic framework, and really we've launched, and now we're sort of heading into regulatory orbit. Certain things that you just do day in, day out. But there are a couple of other pieces that we're going to be building into the mix as well. So for 2023 to 25, we had a strategic framework, and now we have one from 2026 to 2028. And we keep our strategic plans short rather than the 5-year model that many do, because things are moving really quickly in the world, and we need to be agile. And one of the things that a small regulator can do is be agile, and so we're trying to do that to keep pace. So we're working to continue with some of those regulatory pieces day in, day out, renewal of licenses, taking in applicants who want to become trainees, administering exams, all the regulator 101 type work that we do. One piece that we are going to be developing over this strategic plan timing is we're going to be talking with the professions about creating a level of continuing professional development for a profession that's already well-versed. CPATA has to walk a fine line between making sure that licensees are as equipped as possible for evolving areas of practice with being overly prescriptive or top-down in approach. You saw at the outset how diverse all of our practice settings are, both in terms of where people serve, who they serve, how they serve, what industries they serve. So we recognize that. So as we look to continuing professional development, we want to make sure that we're recognizing that licensees in their own unique environments They know their practices, and they will be best placed to figure out where there are areas of growth, of skills upgrading that might best be suited for their area and to ultimately serve the clients. So during the strategic fall, possibly as early as this fall, but probably a little later than that, we'll begin to reach out to interested groups, particularly licensees, to get perspectives about this area, and with it, another related piece around return to active practice. We have an inactive practice category. Often that's taken by people who are on short-term leaves, be it illness or a parental leave. Those are always magical, and sleep depriving. And, you know, those are great opportunities, but if it's a longer period, at what point do you start to have possible skills erosion? And what might be the requirements to then return into active practice? So as we look at continuing professional development, the related piece that we will ask about will be what are the standards or requirements we should be considering for return from a leave of absence. So CPATA will be introducing some requirements, but we're keeping it quite open right now, and we're going to be really listening carefully to the professions and to consumers and the needs out there to make sure that we can make decisions that are in the public interest. And we're going to go slowly on these areas to make sure that we have these in balanced form. So those are the things to look forward to, and if you're curious about the other pieces on our to-do plan, please check out our document online. But for today, we're going to conclude by just extending a message of thanks to everyone who got us to this point. You know, 5 years is a great milestone, and it's just me keeping you from cupcakes, or from Q&A and then cupcakes. But I did want to thank the Government of Canada for recognizing the importance of these professions and for extending privilege even before creating a college, recognizing the importance of the work and the client's need to have that protection. I want to thank IPIC for a relationship that has become increasingly productive over time. The comments and the statements on our calls for comment have been very helpful and well received. I know that to our founding directors and to our licensees in particular, this has been change 101. This is a complete unknown that people had to work through, and so that creates occasional friction, but also learning opportunities and growth. And I know I've grown through this. Our organization has grown through this. We hope that licensees are coming to understand the work and coming to an understanding of the role that we provide, the value we seek to provide in the service that we try to play on behalf of licensees and all Canadians. I couldn't thank everyone here, but I'm super grateful to a supportive board, and most importantly to me, to the staff. I was just sharing to a former colleague and mentor of mine that I come to work, and by coming to work, I mean walk down my stairs to my basement every morning, and I'm in awe of this team. They are so dedicated. Jen joined before there was an enforced date. She took what I would call a regulatory leap of faith, that the lights would get turned on, and she was there to make sure that when you flip the switch, there would be light. You know, this didn't happen from zero, so there's pre-work that was done by many on this team, Victoria, Sean, and then there's this whole group, and the work that they do, the professionalism they provide, that service culture, and that true team spirit is just nothing short of inspiring for me, and so I'm grateful. It really helps us advance this mandate for licensees, for innovators, and for all Canadians. So thank you, everyone, and with that, we'll open it up for questions.
We actually already have a question online, Judah.
Awesome.
Since CPATA is an independent regulator, why are the bylaws drafted in conjunction with the Department of Justice?
Yeah, so in Canada, there are ranges of independence for regulators. And so if you go to Quebec, for example, any professional order will have their rules of conduct must go through the Ordre de Profession. There is an oversight group that will review and possibly come back and make suggestions, but you need their approval before anything comes into force. So this is not dissimilar. This is the federal government saying, the bylaws are yours, but they must meet our requirements from administrative law and drafting perspectives, and so they work with us, and they are considered statutory instruments. And so any statutory instrument is going to go through the Department of Justice. So they really are a partner for us, but we also need to work along their timing and in line with their approaches to drafting.
So I got a question. I'm guessing this falls within the scope of your Audit and Risk Committee, which I think is Scott and Sean, but feel free to throw it to any of your other friends. And yours? Yeah, but you've got many other friends up here. So if I understand the numbers, we've got the two reserves total about 3.2 now and expected 3.6. Is that correct?
Yeah, 3.1 now, and the target is 3.6, and we expect to be slightly above the 3.6 by the end of the year.
Okay, great. So are there any, I'm not suggesting you engage in high-risk loans, but are there any principles, guidelines, written or otherwise, regarding investment of those funds?
So we do have an investment policy now, but mainly it is very conservative and say that we can only invest in non-risk. So non-risk investments such as GICs or government bonds or things of that nature. We're steering away from equities at this point.
Okay. Is that in writing? Is that a written
Yes.
policy?
Yep.
Internal or posted?
Posted.
That's posted.
Yep.
Okay. Where? On the financial section?
Yeah, on the About Us under policies.
Okay. All right.
Grant, also, this morning at our public board meeting, our Audit and Risk Chair, Bob Clemendeau, actually talked about that. And it was recorded and it's on the website too. So if you want to hear Bob's thoughts on it,
Okay.
you can also tune into that.
Okay, it's okay as long as I don't hear high-risk loans. That's good.
Oh, no.
Oh, yeah, no.
Okay.
Yeah, no.
Thank you.
Thanks, Grant.
I suggest that we alternate one in person and one online, if that's okay. So a general question about licensing, I think this might be for Jen. Would CPATA consider letting Class 3 trainees write the knowledge exams without the 12-month experience requirement? It seems like the knowledge exams might be a way to show potential supervisors' commitment to the agent pathway.
Sure, I can take that question. I think that right now we're still in the process of gathering data. This is only the third year that we're administering those new exams. And we had sufficient data in order to reestablish the eligibility criteria from 24 down to 12. So it's not outside the realm of possibility that in the future it might be further decrease. But for the time being, we're gonna try out the 12 months for a little bit longer, and just make sure that candidates are set up for success to get through that exam. But we do also hope that people are who are writing at 12 months that are able to pass that exam, who might be looking for a supervisor, are able to get that experience sooner rather than later as a demonstration of their commitment to the professions.
Hi, everyone. For those of you who don't know me, I'm Jason Hines, the current president of IPIC. This is at the risk of delaying the access to cupcakes. This is less of a question, but more of just a few general comments. First of all, congratulations on an incredible 5 years. We remember, and IPIC pushed very hard for the creation of some governing body for many, many decades. And to see what it's become over the last 5 years is truly incredible. So congratulations to you, Judah, Ruth, Jenna, Wynn, over and the rest of the staff and the board, because you've done an incredible job. Particularly on issues like the fees, obviously our members are very, very pleased that the resolution was adopted today, so we're very happy. So thank you on behalf of our members that that's gone through. And thank you for your support on issues like privilege. We do appreciate the work that you're doing on that. That's obviously an issue that we take very seriously and we think about very, very significantly. So we look forward to many, many decades of working together in the future, and congratulations again. Well done.
Thank you so much, Jason. Thank you.
I have another question online. Does the registrar consult with a practicing agent before exercising discretion under Section 38.1, subsection 1 of the CPATA Act, i.e. regarding complaints?
I am going to Google something right now. I think the question more generally is when does the registrar, that's me, consult with agents before making certain decisions that might relate to a complaint that's come in that might go to the investigations committee or discipline committee. So the section that was mentioned, it was 37.
38.1, subsection 1.
Okay, so just so everyone's on the same page, this is a provision that says that when there's a complaint received by the college, the registrar must consider all of them, anything related to professional misconduct or incompetence by a licensee, and may, subject to the bylaws, dismiss any complaint in whole or in part. But if not, then if they don't dismiss it, then it goes to the investigations committee for consideration. So the approach is basically this: if it is outside of our jurisdiction, I will dismiss it. And I've done this at least once, twice. We're not a high volume regulator. If there is any possibility that the complaint, if it was accepted to be true, could be interpreted as raising a concern about ethical conduct, I will typically refer it to the investigations committee. The investigations committee can then determine what, if anything, to do on the basis of that complaint. And Victoria explained that process. I would say that more often than not, before it even comes to my desk though, somebody will likely reach out, not sure how to complain, and if they're not sure how to complain and they don't use magic words like, this is a formal complaint against licensee X, we will write to them and say, it sounds like you're having an issue. Is this something you would like to try to informally resolve? And we try to do that first. And so these come to me quite rarely, but there have been a couple of occasions where there's not a need to consult with the licensee per se if the question is really, for me, quite narrow about whether or not this is within jurisdiction or not.
Currently, we don't have any other questions online.
I think we're good. And I don't see any other questions from the floor. So I think I am in a position to adjourn this meeting of the 2026 College of Patent Agents and Trademark Agents AGM. And thank you again, all of you, for coming to join us. Thank you.